My name is Justin McKenna, and I joined Janie about 6 years ago in a conversation that, as you can guess, developed, and we brought some friends on board. But it is really because of Janie that End of Life Ireland is what it is and has become. So I want to give her all the credit. The dynamism of the lady, built in such a compact body, has proven to be completely infectious and has brought us here. But I came from a different background. I'm a lawyer, I'm a solicitor, I'm a probate solicitor. So you say, well, what's that? And I grew into it, I suppose, through a process of acquisitions of law practices. And for most of my practicing life, I would have dealt with wills. As I said recently, and I always say it, we have two types of wills that we create. I call them wills for the newly weds and wills for the nearly deads. So I became used to the nearly deads as a part of what I did and still do, as I talk to them about how to cope with the administration of what they leave behind. But that's the point, that it wasn't until 1996 that I had to think about what would happen before the death. We were always conscious about how we would handle the remnants of a life and deal with after-death issues. Wills speak from death. So what happened in 1996? Well, let's talk you through this, because I'm going to just give you a legal perspective on the subject that we're going to analyze in the next 2 days. It was in 1993 that the concept of suicide was decriminalized. But at the same time, to assist in someone else's death was prescribed as murder, punishable by 14 years imprisonment. Now, around about the time this was taking place, I wasn't really concentrating on this subject of assisted dying. It really didn't come into my radar. But I was involved with the Law Society of Ireland on their Probate Administration of Trusts committee. And thereby, I became involved and interested in case law that was emerging. And in 1996, the Supreme Court, in a case that is known as in re award of court, ruled that a woman in a permanent vegetative state could have her life terminated. Now that, although it was an anonymous case, the names were withheld, including the names of the protagonists, let's say. I knew the family that was involved personally. It was Ireland's first right-to-die case. It involved the sad story of Lucy Chamberlain, who in 1972, at the age of 22, underwent a minor investigatory procedure in a Dublin hospital. Something went wrong, and she suffered global, irreversible brain damage and was made a ward of court. Lucy's suffering deeply affected the family, and Margaret, her mother, lost her husband Tom because of what was happening in the family. It was tearing them apart. She became increasingly unhappy at the determination of the various institutions that Lucy attended to keep her alive. These were run by religious orders, and Margaret herself was a religious person. She consulted theologians and church authorities and was satisfied that by withdrawing nutrition that was being fed artificially, it was allowable from a Catholic standpoint. She took her case and won in the High Court, and the decision was then appealed to the Supreme Court by the Attorney General, supported by the Catholic institution and the Guardian ad litem, where she won again. Statements by the Medical Council and on board Alternate, which is the Irish nursing body, left doctors and nurses fearful of implementing the family's wishes in the light of the 1993 Act. So she was brought home, where she died 8 days later under the voluntary care of 1 doctor and 8 nurses. Margaret wrote later that those 8 days of dying were more peaceful than the previous 23 years of so-called living. Now, in over 30 years, there has never been a successful prosecution for the offence of assisted suicide. The case of Gail O'Rourke in 2015 was the only one that actually made it to the courts, and the judge at the time directed the jury to return a verdict of not guilty. So that would have been the case background bringing us through into the 2015s, or the teens of this century. And when Janie said, let's think about what's happening, because we were on the periphery of other campaigns that had taken place, the Repeal the Eighth and the referendum on same-sex marriage. There was change in the air. And Janie said, what about Mary Fleming? What about Gaynor French? So we started looking into it, a little bit more research. And I realized then what had happened in my own practice, that before 1996, I was only concerned with after death, with the wills that said, well, what happens after somebody dies? But in 1996, the Powers of Attorney Act was passed, and that act introduced a concept which surprisingly hadn't existed before then, but that was the concept of an enduring power of attorney. In other words, if somebody should lose the capacity to make decisions, who then makes the decision for the person who is still alive but has lost the power? And for the first time, we were allowed as individuals to choose somebody to act as our attorney in an enduring manner. Because before that, it was amazing how casual it would have been to simply go down to the bank manager and say, look, my mum or my dad can't handle these decisions, they've got dementia. And the bank manager said, look, it's all right. If you sign on that person's behalf, I'll make sure that everything's fine. And this was just was accepted. And curiously, we all sat back and allowed it to happen. But then when the legal process was now taking its course, I got interested in it, and I developed a software package for solicitors that was used up until last year when there was a change in the law. And I'll talk about that now because the next change that was going to take place occurred in 2015. But before 2015, there was something that motivated the legislators to push on it. There was the Fleming case, obviously, was one. That was 2013. And prior to that, there was the United Nations Convention on the Rights of Persons with Disabilities that removed this idea that you had a status as a person who didn't have capacity. And status was what it was all about, going back to the lunacy regulations of 1871. And now it was a matter of function, not status. So everybody would be presumed to have the capacity until, in a functional sense, a doctor might say, this person cannot make a decision right now. but it proved to be a challenge to create a law that would do it overnight. But they passed the act, which was the Assisted Decision-Making Capacity Act, in December, just about, I think, it was the last act of 2015. The President signed it, I think, on New Year's Eve. And it didn't commence for another 8 years. You know, it set up the Office of Decision Support Service, so we had some mechanical device taking place, but the Act itself took 8 years to implement, and it was introduced last year, April of 2023. And that meant that we had one other element to add. Part 8 of that Act introduced the concept of advanced healthcare directives. Now, this is something that would be common enough in other countries. In the US, I think they call them living wills. But for us, it was a first. And for me as a practicing solicitor, it meant that I could now talk about how my client was going to die, and that for the first time they could have a say. But curiously, the say is in how not to die rather than how to die. And therefore, we have these templates. The Hospice Foundation created one which is called Think Ahead. So that's thinkahead.ie. The DSS.ie has a template for, I suppose, a government-approved form. EOLI.ie, that's our organization. We have our own template as well, with some of our own refinements, I suppose. So the templates exist, but there's an extraordinary well of ignorance out there, not only within the legal profession, because this isn't really a legal matter, it's a medical one. And I think the opportunity is there now for the medical profession to understand that the patients they have an opportunity to articulate how they would choose not to die. I suppose one of the things from a legal practitioner's point of view is this idea of having a conversation. So the first conversation is about the wills, is the material aspect. The second conversation is about the enduring power of attorney and making decisions on behalf or having others make them for you in the event that dementia might set in. And the third conversation is this one I'm talking about now. And that brings us to the idea that you can create your own directive. And the Department of Health has set up the Health Service Executive National Office for Human Rights and Equality policy. It's a bit of a mouthful, but it exists. And one of the things about the HSE, the HSE is the health authority that we operate here in Ireland. It's a clumsy organisation at the best of times, but it's full of goodwill, and it works somehow. And those who go through the process will come out at the end generally happy with it, but it's still finding its legs in so many ways. But this framework that the National Quality Improvement Team has in its literature has adopted a human rights approach to healthcare and recognises the freedom principles of fairness, respect, equality, dignity, and, of course, autonomy. So we have a structure, we have a mechanism, we have the means to do all these things. So where is the law going to take us next? When the next bill, because it will be another bill, comes through, and we have our legislation. All the functional aspects of how to implement it exist. It could even happen in a one-liner if we were to simply repeal subsection 2 of section 2 of the 1993 Criminal Law Suicide Act. And in repealing it, take away the criminality of assisted suicide. And then you're left with an open field. Now, obviously, since Fleming, we have to introduce restrictions. We have to put in safeguards. And that, of course, will be the meat and the flesh of what the legislation is going to say. And during the course of today and tomorrow, we're going to hear contributions that will help us to focus on what those safeguards are, what those limitations will be, how we handle the slippery slope, and where do we allow the limitations to exist. It is the stuff of conversation, argument, and conflict maybe, but it's fun. It's fun because we are going somewhere with it. We have a legislative development this year, and that means that the recommendations of the Joint Oireachtas Committee on the subject of assisted dying will bring us to the next level. A third private member's bill is now before Dun Laoghaire. However, this administration is in its dying days, and with a little assistance, it will be dead before the year is out. Intolerable suffering is as good a reason as any for its demise. I leave you on that.